Marvel is suing a number of its comic book artists to maintain full control of iconic superhero characters including Thor and Doctor Strange. Is Marvel in danger of losing the rights to many of its iconic characters? Is the billion-dollar Marvel Cinematic Universe in serious trouble? Find out on this episode of Reels and Gavels.
There is something called the Marvel method of writing comics, which is really the Stan Lee method. I would say to the artist, look, this is the plot I want. And I would either tell them in a few words what the story was, or I would write an outline on a page or 2 pages or a few paragraphs. And I'd say, you go ahead and draw it any way you want. It doesn't matter. I'll put the words in and tie it all together.
On September 24th, Marvel Characters Inc., the copyright owner of a number of famous Marvel characters, sued comic book artist Larry Lieber and the estates of artists Steve Ditko, Don Heck, Gene Colan, and Don Rico. The lawsuits filed are seeking a declaratory judgment asking the court to confirm Marvel's interpretation that it is the rightful copyright owner of a number of famous superhero characters, which these artists originally worked on back in the 1960s. Now, the characters in dispute include some famous characters such as Iron Man, Ant-Man, Doctor Strange, Thor, Blade, and others. Marvel decided to file these lawsuits in response to a number of termination notices it received from various creators which stated they were terminating their assignments of copyright to Marvel. So why can these artists now terminate their agreements? Why didn't they try to do this earlier? This is due to the Copyright Revision Act of 1976. Prior to the 1976 Act, copyright used to last for 28 years with a possibility of a 28-year extension for a total maximum term of 56 years of copyright protection. The Act extended copyright protection by an additional 19 years. So, copyright authors who made works prior to 1978 were granted the right to terminate their previous assignments of copyright or basically go back on their past agreements after 56 years, so that they could fully reassign those 19 years and take advantage of them as they chose. For this reason, artists like Larry Lieber, who worked on a number of comic books published in 1962 to 1964, are now seeking to terminate their alleged assignment of copyright 56 years later so that they may financially exploit that additional copyright period. So why do I say alleged assignment? Well, that's the crux of this issue. The central question is whether these artists created these characters as independent contractors or freelancers who then assigned their copyright to Marvel, or if they were in fact Marvel employees. Now, if the artists were independent contractors, then they have the right to terminate their assignments as they would be considered the original authors of the works. However, if the artists were employees, the characters would be considered to be created by Marvel, with no assignment ever taking place. This is due to what the law considers a work-for-hire relationship. If a work is considered a work-for-hire, it is considered to be authored by an employer and not the employee who actually created the work. So, were these artists employees? Or were they independent contractors? Marvel's arguments are that any contributions made by the artists were at the instance and expense of Marvel, which is the test many circuit courts use to determine if a party was an employee or an independent contractor. If the instance and expense test is satisfied, there is a presumption that a work is a work for hire, and this presumption can only be overcome by a written agreement to the contrary. Now, the Second Circuit has explained that a work is made at a hiring party's instance and expense when the employer induces the creation of the work and has the right to direct and supervise the manner in which the work is carried out. Basically, instance refers to whether the hiring party, Marvel in this case, directed or participated in the creation of the work. Expense focuses on the nature of the payment. For example, a fixed money one-time payment is indicative of a work made for hire, unlike agreements that present the creator with royalties or other forms of payment. Now, Marvel is arguing it had the right to exercise editorial and creative control over the artist's work. Essentially, the artist would work on a certain comic book and then they would submit that comic book to Marvel, and Marvel would give feedback and ask for revisions and things of that nature. Marvel also argues that they paid per page for an artist's contributions, not with royalties, and that the artist worked with the expectation that they would be paid by Marvel. In other words, that this was done at the instance of Marvel. The Supreme Court, however, likely wouldn't agree with the way this test is being applied. The Supreme Court's view is that the term employee means an employee under the general common law of agency, rather than the common way that you would understand the term when speaking with someone. Factors that the Supreme Court might consider to determine whether an individual is in fact an employee include things such as the source of the tools used to complete the work. For example, where did they get the paintbrushes or pencils that they used? Were they provided by the hiring party, or did the person working on the comic books have to buy these at their own expense? Another factor is the location of the work. Was this done at the office, at the Marvel offices, or was it done at home? To what extent did the hired party have discretion over when to work, how long to work, who was setting the hours? Was the work part of the regular business of the hiring party? Did the hired party, these artists, receive any kind of employee benefits? Or did they receive special tax treatment? All of these factors and many more are considered under the Supreme Court's test. Now, if you consider some arguments that have been used in the past to kind of predict what might be argued by the artists involved in the present lawsuits, a good example is Jack Kirby. Jack Kirby was an artist who also fought Marvel in a very similar dispute several years ago. In at least Kirby's case, and I suspect many of the other artists now being sued, but please don't take this as a confirmed fact because we don't know the exact facts of this case yet. But I suspect these artists didn't receive benefits, nor a steady salary, nor reimbursements for certain expenses such as, any tools they might have used, and they mostly worked from home at their own schedules under a process some have referred to as the Marvel method. Now, the artists often also worked for other competing comic book companies at the same time. In other words, in my view, this is a typical arrangement you see with freelancers, not with what you would consider employees. Now, an important point to mention is that the artists would likely be co-authors of the characters and not sole authors if they win. The difference between being a co-author and a sole author means that they wouldn't necessarily be able to stop Marvel from exploiting the characters in future movies. In copyright, each co-author has an undivided interest in the copyrighted work as a whole, and therefore, each co-author can do what they want with the work without getting permission, as long as the other party gets an equal share of any profits. Co-authors also typically won't be able to enter any exclusive deals for the copyright work without the other co-author's permission. Now, either way, this is likely to be a huge case if the Supreme Court decides to hear it again, which I suspect it will unless everyone decides to settle, which is also likely because Marvel is going to be pushing to settle this as much as possible. In my view, the Supreme Court is also eager to hear this type of case because of the manner in which the circuit courts have been emphasizing the instance and expense test over the common law of agency test. I can't wait to see what happens, but personally I hope it does reach the Supreme Court, as I think the way the circuit courts have interpreted work for hire doctrine is incorrect and not in line with the intent of the Copyright Act. Either way, one thing is for certain, the stakes could not be higher. This is a multi-billion-dollar property. And let's be honest, win or lose, the MCU isn't going to go anywhere.
Debuting for the first time in the MCU, She-Hulk is coming to Disney+. Bringing a whole new different vibe to the MCU, Moon Knight is Secret Invasion. Ironheart will be Armor Wars. Baby Groot, Thor, Love and Thunder. We're moving ahead with Blade. We've got a lot in store at Marvel Studios, and Disney Plus is key to the interconnection and expansion of the MCU.